Hello everyone, welcome to Educate in channel. So in this video, I will be discussing about amendment of the constitution. So it is a part of Indian polity. This is the first part of this particular topic, the amendment of the constitution. So why the amendment is required of any constitution? So to adjust itself for the changing conditions and the needs around the country. So there is a need of amendment of our constitution. Our constitution came into being on 26th January 1950. So this particular amendment of the constitution, particularly Indian constitution, it is neither as easy as in Britain nor as difficult as in USA. That is, in Britain, it is very easy to amend a constitution. However, in US, it is very difficult. But with respect to India, the amendment of constitution is not easier as in Britain and not so difficult as it is in USA. So why do we need the constitution amendment? To adjust itself for the changing conditions and needs. So this is the why. Then which article will talk about the amendment of the constitution? It is article 368 and in part 20 which deals with the powers of parliament to amend the constitution and its procedure. That is in article 368 and in part 20 this particular powers of parliament to amend the constitution and its procedure is mentioned. So the parliament is only having the power to amend the constitution and its procedure is laid down in this particular article 368 in part 20. So what is the meaning of amend? Amending of any of the constitution is either it can add or it can variate the existing provisions or it can repeal any provisions it is removing by following the certain procedure which was mentioned in article 368 in part 20. So Parliament cannot amend the basic structure of the constitution. So our constitution is having certain basic structure like fundamental rights. So with respect to this, the parliament cannot amend the basic structure of the constitution. So it is ruled by the Supreme Court in Keshavananda Bharati case, which is happened in 1973. So the parliament is having the powers to amend the constitution, but however, it cannot amend the basic structure of the constitution and it is ruled by the Supreme Court in Kesavananda Bharati case, that is 1973. Then what is the procedure for amendment of the constitution? An amendment of the constitution can be initiated only by the introduction of a bill. A bill is a document for the purpose in either house of parliament and not in state legislatures. That is, we already seen the article 368 in part 20. It deals with the powers of the parliament to amend the constitution. That it is clearly stating that the amendment of the constitution is only possible by the parliament. So to amend the constitution, a bill should be introduced in either of the houses, that is either in Lok Sabha or Rajya Sabha. Then, and it will not happen in the state legislatures. Then what is parliament? Parliament includes Lok Sabha, which is called lower house, Rajya Sabha, which is upper house, and President of India. These three units comprises the parliament. Then what is state legislature? State Legislative Assembly is called lower house, State Legislative Council, which is called upper house, and like President of India, for each state, governor will be there. So, State Legislative Assembly, State Legislative Council, and governor concludes the state legislature. So, amendment of the constitution can be initiated only by introduction of a bill for that purpose, particular purpose, in either house of parliament. Then, and already bill is planned and it is prepared and it can be announced in either of the house of the parliament, then a bill can be introduced either by a minister or by a private member, and it does not require prior permission of the president. So with respect to money bills, president's prior information is required. That is, president prior permission is required to pass a bill in or to introduce a bill in parliament. With respect to money bill, the permission of president is required. So with respect to this bill, that is amendment of the constitution, it can be introduced either by a minister or by a private member. So in this case, there is no requirement for the prior permission of the president. And once the bill is introduced in the parliament, then it must be passed in each house by a special majority. So first, bill should be introduced only in parliament, and bill can be introduced by either minister or a private member. And thirdly, bill must be passed in either in each houses, that is each of the house, that is Lok Sabha and Rajya Sabha, by a special majority. So what is special majority? That is 50% of the total membership of the house. So what are the total membership of the house? In that 50%, and a majority of 2/3 of the members of the house present and voting. So 50% must be compulsorily should be present, and a majority of 2/3 of the members of the house present and voting. That is called special majority. Then, and each house must pass the bills separately. So in Lok Sabha it should be passed, and in Rajya Sabha it should be passed. There is no provision for joint sitting. So this particular joint sitting will come when deadlock is the situation. Meaning in Lok Sabha the bill has been passed, but in Rajya Sabha the bill was not passed, or else the vice versa. In either of the houses, if the bill was not passed, that particular situation is called deadlock. So at that particular situation, the president is having power to constitute, that means to join both the houses and sit together, and they conclude on that particular bill and then they pass together. So that particular provision is not there with respect to amendment of the constitution. Then next one is amending the federal provisions. That is, the provisions which are with respect to state and central are called federal provisions. And if the amendment belongs to the federal provisions, that means Parliament want to amend the federal provisions, it should also be ratified by the legislatures of half of the states by a simple majority. That is, a majority of members of the house and voting. That means a bill was introduced, and this bill is particularly for amending the federal provisions which is related to both the state and central. At this particular case, apart from the special majority of the either of the houses, that is Lok Sabha and Rajya Sabha, it should also be ratified by the legislatures of half of the states. That means each state will be having certain legislature, that is State Legislative Assembly and State Legislative Council. So with respect to this legislature, this particular amending of the federal provisions should be passed by a simple majority. That means in a state legislature, it should be passed by a simple majority. That means the majority of the members of the House present and voting. And it should be ratified by the legislatures of the half of the states by a simple majority. Meaning in every state it need not be passed. So half of the states can accept this amending the federal provisions and with a simple majority of their state legislatures. Then, so once the bill is introduced and it is passed, then it is required the president assent. A bill to become an act, it requires the president assent, means it is signature. And with respect to the amendment of the constitutions, a bill was introduced. That bill passed in both the houses, and if it is related to the federal provisions, it is ratified by the legislatures of the half of the states. So this was all done. Then it will reach the president assent. At this particular point, the president must give his assent, meaning the president has to accept the bill. So he should not withhold the bill, or he again return to the parliament for reconsideration. For reconsideration, he should not send or he should not withhold. He has to give his assent. Then once the president gave his assent for that particular bill, it will become an act. That is Constitutional Amendment Act. So what are the types on which the amendment of the constitution happen? It is special majority, already we have seen, and also through the ratification of the half of the states by a simple majority with respect to federal provisions. But some articles provide for the amendment of certain provisions of the constitution by a simple majority of parliament. So let us go to back, that is article 368 in part 20. It deals with the amendment of the constitution. Okay, but some articles provide for the amendment of certain provisions. So there are certain provisions in the constitutions. For example, I would state that is schedule 1 or article 2 with respect to the union and its territories. So at this particular provisions, there will be amendment. So these articles which are talking about certain provisions of the constitution that can be amended, so for that it won't come under Constitutional Amendment Act. So these amendments which are done through certain articles for particular provisions, for which it is not called as Constitutional Amendment Act as per article 368. So how many ways are there to amend the constitution? So by seeing all the above points, we can conclude with 3 ways. Those are amendment by simple majority of the parliament, amendment by special majority of the parliament, amendment by special majority of the parliament, and the ratification of half of the state legislature. So here we have seen that special majority we discussed, special majority of the parliament and ratification of half of the state legislatures we discussed. So with respect to simple majority of the parliament, it is in the case where certain provisions of the constitution based on some articles, if the constitution is amended, at that particular point, simple majority of the parliament is enough to pass that particular bill. So, however, it won't come under Constitutional Amendment Act as per Article 368. So, this is the part 1 of amendment of the Constitution. In the part 2 of amendment of the Constitution and its procedure, we will be discussing in detail with respect to the ways how the amendment of the Constitution or what provisions with respect to amendment of Constitution through simple majority of the Parliament and amendment of the Constitution by special majority of the Parliament and amendment of the Constitution by special majority and ratification of the half of the state legislatures. Thank you for watching the video. Please do subscribe the channel for more videos. Thank you.